Okay, Chair Rubin, we can go ahead and begin now.
Great. Good morning, everybody, and welcome to our first virtual Civilian Oversight Commission conference for 2021. Today, we'll be discussing enhancing accountability, improving law enforcement, the law enforcement discipline process. We have a great panel of speakers lined up to share their expertise with you. You'll be hearing from the Honorable Sidney Kamlager, who is the Assembly Member for the 54th District, Percy Duran, who is Civil Service Commissioner, Gary Engemonson, who is with the LA Police Protective League as Independent Counsel, and Peter Biebring, who is the ACLU Director for Police Practices. This morning, our moderator is my fellow Commissioner, Rob Bonner. He has led 3 federal law enforcement agencies, the DEA, U.S. Customs and Border Protection. He is also chairing one of our ad hoc committees on accountability and improving the sheriff's discipline process. Enjoy the conference, and I now leave you to our moderator, Rob Bonner.
Of a very important and timely topic. Let me just start off by making a couple of observations to set the stage, so to speak. First is that achieving accountability requires that there be a consequence for misconduct, for violating law enforcement policies of a law enforcement organization. Secondly, a good and functioning law enforcement disciplinary system is one of the best ways, and perhaps the best way, of achieving accountability of law enforcement officers, be they police officers or deputy sheriffs. Third, a good system is one which promptly investigates complaints against an officer, and where those complaints are expeditiously adjudicated based on that investigation. That is to say, based on the evidence. The result is that an officer who has engaged in serious misconduct, such as the use of excessive force or lying in a report, is disciplined, including termination where that is warranted. At the same time, if the evidence does not sustain the allegation, the officer is expeditiously cleared. That's also important. Fourth, if an officer is terminated, for example, for the use of excessive force or racist remark, and this is done in a timely way, the discipline achieves both general and specific deterrence. It specifically deters further misconduct by that officer because that officer is gone. He's been terminated. It also sends a message of general deterrence to all other officers in that law enforcement organization that that type of conduct will not be tolerated, and thereby achieves a level of general deterrence as well. Just one example, if the Minneapolis Police Department had an effective disciplinary system, such as I've just described, Officer Chopin would have been fired well before he killed George Floyd. As a recent OIG report makes plain, we had this briefed to a Civilian Oversight Commission meeting the other day. It makes clear that the disciplinary system of the Los Angeles Sheriff's Department is broken. It's dysfunctional. It's not achieving deterrence. It's seldom holding deputies accountable who have engaged in serious misconduct. It certainly is not holding them accountable in a timely way. So this morning we have a panel of experts to examine whether, number one, whether police officers in this area, including deputy sheriffs who engage in serious misconduct, are being held accountable, and if not, why aren't such officers being held accountable for serious misconduct, including potentially termination? And what are the obstacles to an effective and timely disciplinary process, and what needs to be done to remove these obstacles? So let me set the stage with that. We have as our first panelist or speaker, Sydney Kemlinger, who is a member of the Assembly of the State of California. He's an assemblyman, he's a legislature. And so I'd like to call on you, Assemblyman Kemlinger, to make your remarks. Excuse me, Ms. There you are.
Thank you. So my name is Sydney Kamlager, and I am the Assemblywoman for the 54th State Assembly District, and happy to be here to participate in this discussion on enhancing accountability and improving the law enforcement officer discipline process. I am a voting member on the Assembly Public Safety Committee. I am chair of the Select Committee on Incarcerated Women, and I am a member of the Committee on the Revision of the Penal Code, as well as on the Select Committee of Police Reform. This has been an issue of interest for the California Legislative Black Caucus for a number of years, of which I am currently vice chair. And thankfully, and the phone is ringing, and thankfully, it has become an issue of increasing interest for the California State Legislature. Last year, we had a series of events. We had the killing of George Floyd. We had the killing of Ahmaud Arbery. We had sort of Breonna Taylor. The list goes on and on. We had a racial reckoning. We had a series of discussions across the state on what public safety is, on how to reimagine it, on the relationships between law enforcement and the communities in which they work, and how do we create a society, a state, a system that is equitable, that is just, and that is safe. And at the end of the day, it is important to note and to remember that there are human beings on both sides of this binary formula that we have. Police officers are people, and the folks that they arrest and charge and kill are people too. And at the root of that is what do those interactions look like? And are they the same across neighborhood, across income, across race, across gender, across sexual orientation? And if the answer is no, disproportionately, then that means that we as local jurisdictions and as the state have a responsibility to dig deep into that data, and as a state to come up with criteria and policy that is standardized, that can reflect the change that we want to see. I am sure many folks on this panel, have the numbers that they can share about how this all translates in real time on the streets. But I will say, that the state last year, 2 years ago, took some action with AB 392 around unnecessary force. And I shared a very poignant story about, as even, myself, a middle-class Black woman in, 2 income, 2 children, 2 pet household, with a working husband, living in a, average neighborhood, when the alarm went off in my home and I called the police, and the police were called actually because the alarm went off. When I showed up and the police were in my house, I was scared. I was scared that something might happen to my husband, who I assumed was on his way home because the alarm had gone off. And I didn't know how they were going to treat him because of where we live. And no one should feel that way. And if I feel that way, we should really be having serious discussions about how everyone else feels who actually has continuous run-ins with law enforcement. That was why AB 392 was so important. Last year we had an opportunity to pass SB 731, the decertification bill that says if you are a rogue police officer, or if you're a police officer with a history of bad conduct, of brutality, then that should be known. That should be transparent so that the personnel departments and police departments know who they could be getting if they hire that particular officer. We do know that bad seeds go from police department to police department to police department. And oftentimes that smaller police departments don't have the resources to do that kind of investigation to decide who it is that they're hiring. Last year, I authored a bill, AB 2054, the Crisis Act that has come back now as AB 118, which would create a pilot program funded at $30 million from the state to allow community-based organizations to respond to 911 calls that are nonviolent, non-criminal in nature, so that law enforcement doesn't have to. We know that 70% of the calls that come into 911 are nonviolent and non-criminal in nature, and we know that only 11%, of the calls that are actually require any kind of force or the use of a firearm. And so, while we're talking about ways to have communities feel more safe when they call 911 or when they ask for help, it's also important to think about, how we can eliminate some of the lawsuits and the liabilities that come with these kinds of interactions that can sometimes turn deadly. We know that, law enforcement departments deal with workers' comp, high incidences of liability, settlements, sick time and time off. I can assume because of the mental health aspects that come with the job. And this is also a way to kind of, draw down on some of those costs that police departments and cities are assuming. We're also looking at, the gang database, the issues that came up last year with the fact that law enforcement were falsifying records, into the database, caused the Attorney General to say, I'm not going to use this anymore. This is a right opportunity for us to reimagine gang enhancements and how we use them. We know that 96% of the folks that get gang enhancements and that are in the gang database are Black and brown. How we look at warrants. We also found last year that the only person who can authorize the warrant into the investigation of a law enforcement officer who's been involved in gross misconduct or, an alleged officer killing incident is another peace officer. So that has made it incredibly difficult for prosecutors to be able to do their job. And we've heard from a number of DAs across the state that they have been hampered in their ability to charge, to bring up charges to law enforcement officers who have been involved in those kinds of incidents because of things like this. So I share these examples as examples of how the state is getting more involved in ways that we can uplift issues of transparency and accountability with how law enforcement is exacted in cities and actually in counties with sheriffs, and to say that we have to continue to be uncomfortable in this space talking about issues that oftentimes involve class, race, and gender. Last year I audited the sheriff's departments of Alameda, Los Angeles, and Fresno because of allegations around fiscal malfeasance, increased suicide, use of excess force. And it's really in response to the calls and the cries from constituents, in those counties who've said enough is enough. This is certainly not how we should be providing public safety because it doesn't look the same for everyone. I think that's why we saw Measure J pass overwhelmingly last year. I think that's why we saw this last November, the election of a new DA. I think that's why we're seeing increased scrutiny of our sheriff's department here in Los Angeles County, because people do want a reckoning and they want to know that there is justice and justness in how public safety is really prescribed, defined, and delivered across the counties and across the states. So I will leave it at that because I'm sure my 10 minutes is up.
Well, it's just about up, but thank you for that overview, and thank you for your work in the legislature, Ms. Kamlinger. Um, Let me ask this. First of all, kudos on getting the decertification bill through. I mean, that's so important that a police officer that's terminated for misconduct not be rehired by another police organization. Is that law now in effect?
So actually, I may have misspoke. That bill did not even, it was introduced last year. It didn't even make it to the floor for a vote. So it is being introduced again this year. It is SB 2. It's still is authored by the same person, Senator Bradford, and it will be a priority for the California Legislative Black Caucus. So it is coming back again, and it is a priority also from the Senate Pro Tem's office. And so we're hoping that it will get passed because, to your point, it is incredibly important.
It truly is, and I will keep us informed on that. And if there's something we can do to help, let us know. All right, the next panelist, I believe, in order here would be Gary Engemonson. By the way, Mr. Engemonson, am I pronouncing your name correctly?
Engemonson.
Engemonson. Engemonson. Mr. Engemonson is with the LA Police Protective League as independent or outside counsel, Mr. Engemonson?
Independent. I'm fully employed by the league. They and the 10,000 officers are my only clients.
All right, very good. Well, we're very interested in your views on police accountability and how whether there is accountability now, and if not, what are the obstacles to increasing accountability through a good discipline system or process?
Yes, I selected as the topics from the topic list of the law enforcement investigations and discipline process because we are different than the sheriffs, and maybe looking at our process would be instructive. Officers, I think, have to know that there will be a fair disciplinary process. Many officer contacts are negative, tickets, arrests, disputes, etc., and naturally complaints are common. LAPD runs between 3,000 and 4,000 complaints a year. And by the way, we take every single complaint that is brought to us by a citizen. Internal Affairs investigates most of them. At the end of the investigation, a captain recommends if the complaint will be sustained or not. If sustained, the chief of police then decides on the penalty, and the penalty can be suspension days or sending the officer to a board of rights for termination. Officers can appeal suspension days and termination recommendations to what is called a board of rights. It was created by the city charter. It is an evidentiary hearing in front of 3 board members. It has been in place since 1935, 85 years. The reason that the board of rights system was created was corruption prevention. It was meant to protect the honest cop. In the 1930s, LAPD was steeped in corruption flowing out of City Hall. In 1929, 60 officers were involved with bookmaking. Bathhouse McDonald was arrested and testified to spending $100,000 a year on payoffs, and those were $1930. In the 1930s, Mayor Shaw and his brother were out of control. The brother controlled vice. To control vice, you have to control officers. LAPD officers were paid to look the other way. LAPD officers were bagmen for politicians. Promotion answer sheets were sold. Promotions were sold for $500. The first 10 spots on the lieutenant's test was reserved for payoffs. Merit considered until spot number 11. Honest cops or whistleblowers were easily gotten rid of with bogus allegations, and there was no appeal. In 1935, the charter was changed to give officers boards of rights. They could not be overruled by the police commission or the chief. The chief could only reduce penalties. The chief was also given civil service protection. Mayors could no longer reach in and control the officers or the chief. That was the system for 60 years, and then came Rodney King. 1995, Proposition F was put on the ballot to reform the disciplinary system. The Christopher Commission recommended more civilian control. The board then became 2 staff officers and 1 civilian. The civilian came from a pool formed by the police commission. It also took away the chief's civil service protection, and the mayor could now reach back into the department but not to individual officers. In 2014, 4 captains in separate lawsuits confirmed that the chief was subverting the Board of Rights system. Each of the 4 captains related how they were retaliated against by the chief when they failed to terminate an officer when the chief's recommendation was for termination. In each case, the captain, after listening to the evidence, found that termination was not warranted. The captain, of course, owes his or her rank and promotion opportunities to the chief. The chief was essentially influencing the jury pool. So much for a fair and impartial hearing. So in 2018, Charter Amendment C was placed on the ballot and passed. It gave an officer an option to choose 3 civilians for board members. Civilians are not obligated to the chief for their promotions. The police commission selects the pool for civilian board members. Most are attorneys or labor arbitrators. On June 13th, 2019, they went into effect. Civilian control was enhanced. Department politics impact on decisions were reduced. Due process is important. The curtain for officers is guilty before investigation. For 85 years, LAPD officers have had the right to a hearing where they can produce witnesses and in their defense and challenge the validity of an investigation. Officers can do the right thing. They can report misconduct, they can whistleblow, they can make arrests, and they know that they cannot be terminated without a hearing. The chief decides terminations after a 30-minute briefing by Internal Affairs and looking at a written investigation. A Board of Rights spends several days listening to witnesses and delving into the details of the investigation, with a chance for the accused officer to cross-examine witnesses and call their own witnesses. Checks and balances are the foundation of the American system of government. However, the chief retains the needed power to neutralize a bad officer. The chief can immediately require any officer to turn in their badge and gun, order them to refrain from using police powers, and remove them from contact with the public. It is done all the time. It can be done immediately if there is a bad shooting. The chief can remove an officer from payroll by serving the officer with charges and ordering them to a Board of Rights. Pay stops in 30 days. This gives the officer time to find medical insurance and other sources of income. The standard of proof is preponderance of the evidence, more likely than not, 50% plus the weight of a feather. There is a morale factor. Officers are under terrific pressure from the current anti-police atmosphere. Almost all of the nationally proposed reforms are already in place at LAPD. Boards of rights are in the officer's DNA and have been in existence for 85 years. Officers must believe that they are to be treated fairly. Every American has the right to due process. Morale is down from lack of support, and there is a consequence to that. As of chief's report to the police commission, public contacts from police officers are down 27%, arrests are down 23%, homicides are up 38%, and shootings of victims by suspects are up 145%. And that completes my presentation, and I guess I'm supposed to announce that the Director of Police Practices for the ACLU, Peter Bybring, is next.
Well, let me do that for you. But thanks for that really interesting historical overview of the LAPD and the efforts to root corruption out of the LAPD back in the 1930s. Let me ask you one question before I turn to Peter Bybring, and that is,
Sure.
The LAPD system, as I understand it, the police department recommends discipline, but the ultimate that the police commission itself can either increase or decrease discipline after the recommendation or the I guess its recommendation of discipline has been made by the police department itself. First of all, is that correct? Am I generally correct in that? How would you phrase it?
No, that's not correct. It starts off with the police chief looking at the investigation and saying, officer, you did something wrong, and filing charges against the officer. Two things can happen. The chief can say that's worth a 10-day suspension. If he says that, if the officer does not draw a Board of Rights in 5 days, he is suspended for 10 days. If he does draw a Board of Rights, that Board of Rights then will look at the case and come up with a recommendation for the chief of police. That recommendation can be accepted or downgraded, but not increased. On the other hand, if the chief looks at the investigation and he says this officer should be fired, he recommends he extends the officer to a board. The officer has no choice. The board then hears the evidence and comes back with a recommendation. If it's termination, the chief signs off on it, or the chief can lessen it, but he can't increase it. So
Does the police commission play any, does the LA Police Commission play any role in that?
no, the role that they play is they choose the pool of civilians that go into the border.
All right, that's different than what I thought. Well, one question that I might ask the panel when we go to question time is whether, looking at the Los Angeles County Sheriff's Department, whether the final disciplinary decision should be vested in the Sheriff Civilian Oversight Commission, which could either adjust it up or down, at least in cases of serious misconduct, for example, where there's somebody has lost their life and there has been a finding of use of excessive force. But that's a question, let me defer that for the moment. Mr. Biebring is with us, Peter Biebring, and he is a lawyer, I believe, with the ACLU, the American Civil Liberties Union, and I know he studies law enforcement issues. Mr. Biebring, you're on.
Great. Thank you, Judge Bonner, for having me. Thank you to the commission. Good to be on a panel, Gary, with you, Assemblymember Kamlager. I want to, at the outset, thank Assemblymember Kamlager for her work supporting police accountability on a number of issues and for carrying the Crises Act this year, which is a really important bill that is a top priority, certainly of the ACLU and of a broad coalition of community-based organizations that are supporting that. So thank you. So moving to the topic at hand, I guess I wanted to address the issue of disciplinary systems from an advocate for police accountability and as somebody who is a lawyer and obviously versed in legal and administrative systems, but also from my personal experience working with community organizations, because I think one of the most important things to recognize about disciplinary systems at the outset is this kind of inherent tension in them, that on the one hand, they are often not trusted by the community and the public as a means for holding officers accountable. I mean, just from the simple principle that generally people, any institution, has trouble policing itself. And that's particularly true, I think, of police departments because of not only the history of abuse that I think incontrovertibly has occurred, not just in LASD, but in departments across California, across the country over the decades and centuries that police have existed, but also because of the secrecy that has shrouded the disciplinary system for years and years. And that has started to change recently with recent legislative changes, just SB 1421 a couple of years ago that has opened that up. But it has been hard to trust disciplinary systems as a member of the public because we just cannot see them working. So the other side of that tension, however, is that even though they are often not trusted, they are indisputably vital for the integrity of police departments. Serious misconduct like use of force, use of deadly force, police shootings, dishonesty in the investigation and prosecution of criminal proceedings, so false statements, false testimony, planting evidence, issues around harassment, racial profiling, wrongful searches and arrests. These issues will not get rooted out of an agency and will grow and fester in an agency if there is not an effective discipline system. There are other systems, of course, that are crucial for police accountability, but they're not enough. The criminal system, well, first of all, relies in large measure on the investigative capacity of the employee. Criminal investigations. And so if there are flaws in the discipline system, that will be a problem for the criminal system as well, criminal investigations as well. But also, the criminal law is simply too low a bar, right? The public deserves better than a police department that is not criminal, right? The standards for a department hopefully will be higher than that. the civil court system, while it is at times effective in unearthing misconduct, rarely results in accountability internally within the department. So when people, there may be millions of dollars in payouts. People, once they victims of police abuse, once they retain their own attorneys and conduct depositions, may very effectively root out misconduct. But at the point at which that happens, typically the administrative investigation has been completed and the deputies are still working for the agency, or officers are still working for the agencies. And you can see that certainly, just to flag, a study of large agencies by UCLA professor Joanna Schwartz showed that LA Sheriff's Department over a 3-year period had payouts averaging $40 million a year, a staggering $4,100 per officer, per deputy, which was the 3rd highest per deputy rate of liability in the country, and was 5 times larger than the Baltimore Police Department, 10 times larger than Miami or DC. So there's some real problems there, but that's not a system that results in changes or in individual accountability, because the deputy don't pay that, the taxpayers pay that. And while there are systems like decertification, which Assemblymember Conlager noted, which is a very important bill, is also a top priority of my organization and a lot of community-based organizations, that system will prevent officers from moving from one department to another, from moving to one department to a new department after they're fired. But this investigative capacity of the state is never going to be able to make up for the investigative capacity of a large agency like the Sheriff's Department. So the internal discipline system is absolutely crucial for an agency's accountability. And one other clarification: oversight, such as the Inspector General, is important in making sure that the department is running, the department disciplinary system is running well. But again, they don't have the capacity, at least as it's currently constituted, to actually discipline individual cases. And that has to be accounted for by an effective discipline system. The other major point I want to make is that this is about a real impact to the lives of the people policed by the agency. LASD remains among the deadliest departments in the country. And if the standards for use of force and officer integrity are not enforced, they're not followed. And so, the impacts where you have use of force, where you have searches and dishonesty, are profound. In addition to those shootings, the LA Sheriff's Department has a problem with deputy gangs that is effectively unique. I'm not aware of any other agency in the country that has a persistent problem, the pervasive and persistent over decades problem with deputy gangs. And that problem arises from a culture of permissiveness of misconduct. And that should be, that's articulated both in the Inspector General's report and in the recent report by Loyola Law School. So in the final minutes of my presentation, let me just say, first of all, the Inspector General's report regarding the Sheriff's Department last week is an absolutely crucial read for anybody concerned with the Sheriff's Department, concerned with the discipline system. It is a case study in a failed discipline system. It is one of the most damning assessments of an agency that I have read, possibly apart from the DOJ report on Ferguson Police Department. As Judge Bonner said at the beginning, quoting verbatim from my notes, that the discipline system at LASD is deeply broken. It is, and I think one of the things that's important here, and I'd love to hear from Gary more on this, is that it's broken in 2 directions. It is failing to identify misconduct and failing to hold officers, deputies accountable for misconduct. But the report also says that deputies don't trust the system either, but there's a wide perception that it's used inconsistently to punish, effectively for favoritism, to punish deputies that are disliked for reasons, and to overlook misconduct by those that are liked, regardless of whether there's actually misconduct at issue. And the system has to work. It has to root out misconduct, and it has to be fair. But in policy, in practice, in the culture of the department, the Inspector General's report in great detail articulates a system that is geared towards allowing misconduct to persist, absolute real implications for the residents of Los Angeles County.
Mr. Brady, let me open up some questions here by just, first of all, I find myself in violent agreement with you that internal discipline systems that function and are effective is crucial to accountability. In fact, I don't think we'll ever have a system in which criminal prosecutions or even civil suits, as important as they are to compensating a family who has been had lost a loved one because of excessive constitutional use of force. Those aren't going to be effective in essentially establishing accountability. And I think the public, particularly in the time we're living in right now, is put it mildly, I mean, demanding that we have a system of accountability for police officers and deputy sheriffs. So I think everything should be on the table. And so my question, it's going to be, I'll start with Ms. Kamlinger. But the question is, if we're putting everything on the table, it really raises the question of POBAR, the Police Officers' Bill of Rights. I mean, first of all, why do police officers have more rights, procedural rights, than any other government employee? And is it time that we actually should be at least thinking of considering of eliminating the Police Officers' Bill of Rights as part of the overall impediment to effective and an expeditious disciplinary process? I'll start with you, Ms. Kamlinger, but I'd like all three panelists to comment on POBAR.
I think it's time. I think it's been time for a really long time. But it's also, when you say yes to that, you also recognize that what will ensue will be intense negotiations and possible warfare with law enforcement labor unions who stand by that. And it's considered, the third rail for a lot of discussions around law enforcement accountability. I was on a panel a year ago and listening to the chief of police, I believe in San Antonio, who talked about the challenges that he faced in management, trying to figure out workarounds to POBAR in an effort to bring some kind of justice to the department and to how protections and public safety were delivered to communities. But that will be a yeoman's work to change that. My hope is that the tenor of the country and the state now that continues to demand justice in this system will allow for some reflective opportunities to happen by police officers and law enforcement in those unions to say, how do we right this ship? Because it is woefully uneven.
And let me turn to Mr. Engemonson. I'm wondering why, you explained some history here, but why do police officers in California have more rights, procedural rights, than other government employees, and particularly when they're carrying a badge and a gun, and maybe arguably should have less rights than other government employees? But why do they have more rights?
Well, you have to recognize what a police officer's job is. It's part of the executive branch of government. It's where the rubber meets the road. The senators and the politicians in Sacramento make up all of these laws, and then they turn it over to the police officer to enforce it. And so if a police officer cannot feel that he's got some backing from the government and from the community when every time he pulls over a car, he's going to lose his house, or every time he pulls over a car, he's going to go to jail, or every time he pulls over a car, he won't be able to return fire when he's being shot at. It's going to have a horrible effect on whether the laws that are passed in Sacramento are done with. And by the way, the Peace Officer Bill of Rights in 1976 had a letter from the ACLU supporting it because the ACLU supports due process. And due process is what the Peace Officer Bill of Rights is all about. When you say that they have a great deal of rights more than anybody else, I really disagree with that. Basically, it says you have to have a fair hearing. You have to have some procedural things. You've got some protections from 10 internal affairs people surrounding you and peppering you with questions from all sides. You have the right to representation. All of those rights mean a lot to the officers that are forced to go out there and do the unpopular things, enforce the law. So they need protection if they're going to enforce the law. It's that simple.
But persons, let's say in the private sector that are employees, I mean, they don't have all these due process rights that are given to police officers, do they? I'm just trying to. You look.
No,
nobody's. Yeah, go ahead.
Plumber is somebody because their pipes are deficient.
All right. So you think because the job is more, it's a more dangerous, demanding job, that police officers are entitled to greater rights than, say, other government employees?
Yes,
Right.
and they have a greater responsibility, and they're on the cusp of enforcing what nobody likes to get a ticket, nobody likes to get arrested, nobody likes a lot of the things that police officers have to do. So if you want them to do them, you should back them up.
Okay, fair enough. Mr. Biebering, apparently the ACLU supported the POBAR back in the day, but where do you stand? What do you think about this issue? Not where you do stand, but what do you think
Sure.
about this issue of, if we're really going to be bold and imaginative and start thinking outside the box about a disciplinary system that's expeditious and that functions, should something be done to repeal POBAR?
Yeah, so it's true. The ACLU did support POBAR when it was originally passed, and I think, and let me also be clear, like I support worker rights very strongly. I worked as an employment lawyer on the plaintiff side before I came to the ACLU, and I deeply believe that it is important to protect the rights of workers against employers, and hopefully that gives me some credibility when I say that POBAR has gone far, far, far beyond any reasonable basic protection for workers against employers, and now effectively insulates, especially the way it has been interpreted at agency levels across California by CBAs, and effectively insulates police from misconduct. And look, I agree with Gary that the officers are where the rubber hits the road on executive action. They are where most people interact with their government. They are, charged with enforcing the laws, and it's precisely because of that they need to be held accountable for abuse and misconduct, and we need to ensure that they are acting properly. And look, backing law enforcement doesn't mean tolerating inappropriate shootings or lying on reports. It absolutely does not. And I think, look, there are a number of specific things, some of which are apparent from the Inspector General report, some of which are larger issues that need to be changed about POBAR. I mean, first of all, and although the ACLU, I should point out, supported the original POBAR, POBAR over the decades through advocacy of law enforcement associations has been expanded and expanded and expanded. And you're absolutely right, Judge Bonner, that it now confers rights far greater than not only private employees, but than any other class of government employees. And I think, the Inspector General's report really sets forth very clearly how the right, for example, to representation has been abused. And, the idea that an officer deserved representation in an interview has been abused to allow those representatives to delay interviews beyond so that the events are no longer fresh in the individual's mind. It allows a representative to a single representative to represent multiple individuals who are involved in the same course of misconduct and help them coordinate their story. Look, it's a best practice in all investigations of law enforcement misconduct when they're, or even not misconduct, but just a use of force, to separate the deputies, interview them, find out what they know before they can confer and get their stories straight. But routinely, and it is in fact, kind of institutionally their duty, a defense counsel will talk to each one and confer and pass information back and forth, making that separation essentially a farce. The other thing is that too often, and this is not just at LASD, in fact, it's more apparent in other agencies, disciplines, even serious misconduct, if it makes it through a disciplinary system that is often stacked against holding officers accountable, it gets overturned on appeal, sometimes by appeal bodies that don't have the experience, don't have the full factual record, and frankly, in circumstances where it makes it difficult for the law enforcement agency, the chief or the sheriff, to really set a meaningful standard on important issues like use of deadly force, like dishonesty. If the chief is, here LAPD is one of the few examples where LAPD is perhaps a more egregious example. In a study of LAPD discipline, it's similar at the sheriff's department, but in both departments, nearly 50% of instances where officers or deputies were initially recommended termination or discharge, those were overturned by the Board of Rights in more than 50% of cases at the LAPD. At LASD, fewer than 50% of those resulted in discharge for a variety of reasons. But if the chief is saying this shooting, which is out of policy, or and it deserves discharge, or this dishonesty deserves discharge, and there are other entities that are allowed to second guess that, that's a real problem. Now, should there be review and appeal to make sure that the process was fair, that there wasn't an abuse of discretion? Absolutely. But in many states, that review is on a deferential standard, so that they make sure that the chief isn't getting the facts wrong, isn't egregiously misapplying his or her discretion. But it should, if we're not allowing the head of the agency some discretion to set the standard, then there's nobody to hold accountable when the disciplinary system fails.
I think you're referring to some of the appellate process beyond the law enforcement organization, which would include appeals to the Civil Service Commission. There's a right to do that, which, by the way, according to the IG board and everything I know, adds enormous delay to the process, if nothing else. And then you have, I think, under collective bargaining agreements, not the sheriff's department, but other organizations have a process where there can be an appeal to an outside arbitrator who is selected in part by input from the relevant union and so forth. Let me go to something else, though, that may be a little bit less controversial than eliminating POBAR. And that is, in the IG's report, one of the concerns, one of the delays, and by the way, very significant delays in terms of the disciplinary process within the LA Sheriff's Department, is the fact that they don't conduct concurrent administrative investigations with the criminal investigation. And I'm wondering, and perhaps I should start with Mr. Engemonson with respect to this issue, because I believe the LAPD actually does do concurrent investigations. But could you comment on the fact that the Sheriff's Department doesn't do these concurrent administrative investigations, and perhaps how it's done within the LAPD?
Little or no knowledge of how LASD does it. But in Los Angeles, when there is a shooting, first of all, FID rolls out, and they roll out. FID is the Force Investigation Division from the department. that rolls out, and they have a criminal team and they have an administrative team. The criminal team's job is to see if the officer broke the law. The administrative team is to see whether the officer violated policy. Along with the rollout comes a district attorney investigator that oversees and sits in on some of the civilian interviews and does the walkthroughs and all the other stuff. And along with that is a representation from the IG's office, the Inspector General's office from the Police Commission, that comes along and also eyeballs everything to make sure that everything is going straight. The officers will be in, I don't know about this delay in the interviews, our officers will be interviewed that night. Very rarely will they be allowed to go home, and that would only be if they've been up for 24, 30 hours, and even the investigators are tired, so they may be sent home for a day, but the interviews take place that night. And then all of it is presented to the chief in 72 hours. At the 72-hour briefing, the chief makes the decision whether the officer should be benched. And by the way, if there's a shooting with a hit, the officer is automatically benched for 14 days. But if the chief thinks there's something wrong with the shooting, the chief can then bench that officer, send him home, send him to the rubber gun room, have him count paper clips, keep him away from the public, whatever the chief wants to do, the chief can do. So there is no delay. Now, the investigation ultimately goes to the SID people over at the district attorney's office to decide whether a criminal complaint should be filed. And then, of course, it goes through the LAPD administrative process, and the jurisdiction of whether it's a good shooting or a bad shooting rests with the police commission. The chief can make a recommendation, but the chief commission makes the call on whether it's you want to say a good shoot or a bad shoot. It's called administrative disapproval if the police commission doesn't like it. So our system, I think, is the most stringent in the United States, bar none.
Okay, and is that the sheriff's department, they don't start the administrative investigations until the district attorney has declined to prosecute if there's a potential for a criminal charge. It's resulting in delays of easily a year and sometimes two before the administrative investigation even starts. By that time, if there are additional witnesses that need to be interviewed, good luck finding them and so forth. So it's in any event, we should look at the LAPD. I think the sheriff's department could look at the LAPD as a model. There's also, I won't get into the Gates-Johnson and perhaps a misreading of that agreement, but that agreement needs to be probably abrogated so administrative investigations can go forward concurrently or parallel with criminal investigations. But let me ask Mr. Biebering, I think you're familiar with this issue.
Yeah.
What should be done here to with respect to concurrent administrative investigations in your view?
Yeah, I think the answer is simple. There have to be concurrent investigations. LASD, to my knowledge, is the only agency that conducts consecutive investigations, that waits sometimes years for a criminal investigation to be complete before it even starts interviewing witnesses. I mean, and you know, Judge Bonner, as you pointed out, it's almost a farce, right? If you wait in a police shooting 2-3 years, which is the length of time it takes for a criminal investigation too often to resolve, and then you go out and interview people, their memory has faded, they've been contaminated with other sources. It is the idea that is even remotely close to best practices or any serious attempt to get to the bottom of what happened is almost a farce. And I think, look, this is a real illustration also of one of the issues that is, you know, structural within the sheriff's department and has been a problem for a decade. You know, it's under successive administrations. As you pointed out, there is a 1991 agreement that said, based on the disciplinary system that was in effect then, there were reasons that it was unfair because they were doing a poor job of separating the administrative and criminal investigations. But there have been structural changes to the LASD that made that, well, there are 2 points. First of all, the only prohibition was on interviewing the officer under investigation, which is only one part of the administrative investigation. There was no prohibition on interviewing other officers other witnesses, doing all the other evidence gathering. And there have been so many structural changes to the way the department conducts investigation that there's no bar that the department could easily overturn that, even that limited restriction, if they wanted to go back to the court and say, hey, we fixed this problem a different way. And the fact that they haven't shows a really deep-seated reluctance to address the problem of the disciplinary system. But this is just fundamental. There's no way to conduct effective administrative investigations if you wait until the close of the criminal case.
It might be, to be a little bit more charitable, perhaps just a misreading of the Gates-Johnson consent agreement. But in any event, I want to bring Assemblywoman Kemlinger back into our discussion here. So let me segue to, it's related to what we've been talking about, but this is also something I drew from the Inspector General, the Sheriff's Inspector General report that was recently issued, just, by the way, just about a week or two ago. But it pointed out that a significant part of the delay in the discipline process of the Sheriff's Department, and frankly, this is probably true of other police organizations in our state, is the fact that once you've finally gotten through the investigation by internal affairs or whoever's doing the investigation, the complaints by a citizen complaint, there's an investigation. The investigation usually doesn't take that long, maybe a month or two. That investigation then goes through a lengthy process within the Sheriff's Department. Ultimately, discipline is imposed, and sometimes the discipline that is imposed is termination of the officer for serious misconduct. But then the officer is able to, in fact, by the way, just one example is I think there were several members of a deputy clique who were disciplined and terminated. This was the Jump Out Boys, I believe. Don't hold me to that. And they were reinstated by the Civil Service Commission. But the real point here is not whether they were reinstated or not. It was the point that's another year or two to the process, so that by the time discipline becomes final under our system, that has, by the way, with all due respect to everybody here, has a lot of due process built into it. You know, it takes a very substantial amount of time. And so that raises this question. I'll try not to be too long-winded about it, but the whole civil service reform movement, this goes back earlier than corruption in the LAPD. This goes back to the spoil system, the civil service reform movement. And it had to do with when a new party came into power in city government. If it was the Republicans, they fired everybody in the local government and hired loyal Republicans, and vice versa, Democrats. By the way, won't get political here. It might be a little bit more Democrats here, but that engaged in the spoil system, but both parties did. And so civil service reform came in. But the reality now is that the civil service, the ability to appeal to a civil service commission, and unfortunately we don't have a member of the commission here. We thought we would, that I could address this question to, but it just raises the question of, do we need a civil service commission where there's been a investigation that's determined that there's serious misconduct, and there's been an appeals process already, by the way, under law. That's a Skelly hearing. Where there's an opportunity to be heard by that officer before serious discipline is imposed, including termination. Do we need a civil service commission anymore, or should we be looking at reforming that so it is not able to simply overturn a decision that's been made within the law enforcement organization or the chief of that organization? Let me start with you. This is the issue of trying to figure out how we could remove an obstacle that is delaying the imposition of discipline for a very, very lengthy period of time.
Well, I will say that, sometimes delays happen because of bureaucracy and due process. And sometimes delays happen because of obstruction. And I think it is important to differentiate between the two. What I can say is, there have been a number of discussions at the state level about, how we can intervene, everything from, really pushing the Attorney General's office to step in and to actually fund a division that could help with some of these investigations, recognizing that oftentimes it is hard for a county, or entities within the county to investigate itself. Because, we're talking about all of this going on, with the sheriff's department here in Los Angeles County, but everyone is still an employee of the county. And so how you investigate yourself, I want to know. There's also a bill that's been introduced that would, offer that non-law enforcement folks can run to be sheriffs. And I think that's an extension of, how do you create some parity and greater transparency and accountability within these systems. If you have someone from the ranks who was in sheriff, how are they going to hold their own, members of the force accountable? I'm not really a fan of greater bloated government. I am a fan of stronger, meaningful government that is equitable across the bar. And as you were talking, I was thinking about some of the committee hearings that I've been on with the Penal Code Revision Committee around parole. And, we have these parole hearings. 16% of the requests for parole are granted, which is an incredibly low number. And one of the reasons I believe that the bar is so high is because the majority of the folks who sit on the parole hearings are law enforcement and correctional officers, who have been trained and indoctrinated, I believe, with a sense that these folks don't deserve their freedom. They have not served their full time. If they get out, they're going to do bad things. And I don't want someone to get out and then commit a crime, and it's on me because I granted them parole. And so I think we should use that lens when we're talking about all of these other commissions and boards. Who are the people who are sitting on them? And what is the lens through which they are viewing their role, the job, the mission, and the outcomes? It doesn't always mean that you create another commission, but it may certainly require you to think about the authority of that particular board, the mission of that particular board, and the true efficiencies that can be created as a result of that particular board. And we don't really talk about those things as often as we should.
Understood. Thank you for that. And we're about ready to turn to questions from our audience. But before I do so, I want Mr. Engemonson, I assume that, well, let me ask you, do LAPD officers who have been terminated by the Board of Rights, do they typically appeal to the Civil Service Commission, or do they I assume they have a right to do so?
No. The only appeal possible from PD Board of Rights is over to the Superior Court. And there, of course, you have to show that some due process or something was violated. And of course, the presumption when you get to Superior Court is that the department acted appropriately. So you go over there working against the presumption that the department's action was.
All right, I understand that. That's interesting. Does that mean that LAPD officers are exempted from the civil service protections?
That's correct. Yes, from the sheriff's type. Yeah, with our appeal process ends at the Board of Rights. From that point on, it's either Superior Court or hit the road. I would like to say, as far as delay goes, to address a couple of things that Peter and Ms. said is
go ahead.
Our regular personnel complaints, 3,000 to 4,000 that we have a year. When Internal Affairs calls the officer up, the interview must be done in 10 days. So there's not a delay caused by the defense or by the officer. So you have the officer being interviewed in 10 days. 1 out of 10 complaints approximately are sustained with some sort of action, disciplinary action done. And a few years ago, our IG did a survey, and it turned out that 1 out of every 3 patrol officers had, because patrol is where most of the complaints come in, of course, they're the ones that are writing tickets and things. 1 out of 3 patrol officers had a complaint hanging over their head. And the internal affairs investigators have a die line of 5 months where they have to get their investigations in. So the process is not slowed down by due process on LAPD. The sheriff's, I have no
Okay. So yeah, I'm just, the FBI, I mean, on the federal side, FBI agents are exempt from civil service, so they have no appeal to civil service. There's an internal hearing process within the Bureau itself. And it's just an interesting model to look at because it eliminates the long delays of a civil service appeal. Peter, I've got a very limited time before I go to public questions, but did you have a one-liner or a two-liner that you wanted to add here before we move to the questions from our audience?
Yeah, I can be very brief. I think, the Board of Rights is pretty well analogous to the Civil Service Commission. It's, a full hearing before authorities that are effectively outside the department. And I think, it is an interesting question. And I think the IG's report contains some interesting recommendations around holding that hearing effectively prior to the imposition of discipline, which is a little bit more like the LAPD model to the extent the Board of Rights the chief can recommend to the Board of Rights without a specific discipline in mind.
Understood. Okay. So I'm thinking that Jennifer, if you're on, this might be a good time to figure out how we go to the public questions.
Sure, absolutely. And we do have a couple of folks who are already queued up. As a reminder to all of the attendees who are on the line, if you would like to ask the panelist a question, please go to the participant window in the WebEx and click on the hand icon. When the hand icon is shaded in with color, that will mean that your hand is raised and you are in queue to ask a question. So with that, we'll go ahead and take our first question. Judge Bonner, you'll be able to do the facilitation and make sure the panelists answer the questions, and then just let me know when you would like to go on to the next one, okay?
All right, that sounds good. And could I also just tell the members of the public and the audience here that it's really important to ask questions here, not make speeches. And if you want to direct it to a particular panelist, so indicate. Otherwise, I will do that. All right, go ahead, Jennifer. Call the first questioner.
Okay, and first we will go with Colin Andrews. Colin, you are unmuted. Please go ahead with your question.
Hello, thank you for your time. This message is for Councilwoman Kamliger. In respect to your recent mention of parole boards, what changes would you like to make in boards that concern decisions that affect both the public and law enforcement agencies? Thank you.
Yeah, thank you.
Well, I think, on that revision committee, we had a number of discussions about how to reconstitute that particular board, having more folks who are system impacted, mixing it up. If you're having academics, if you're having practitioners, if you have any kind of commissioner board that's heavily weighted to one side, obviously, it will skew the kinds of results that you get. And ideally, at the end of the day, the notion of, having a parole hearing is to really move people out of the system and to re-enter them into communities, their own communities. And so why we would design, a board where the composition is comprised of folks who work has been to get people off the streets seems pretty, antithetical to, I think, the mission that most of us are trying to accomplish and see fulfilled, which is to have folks get out of prison and to successfully re-enter them back, into their communities. So I think we have to do a better job of looking at the composition of these boards and making sure that it mirrors the outcomes that we want to see achieved.
All right, thank you for that. Next question, Jennifer.
And the next question will come from Carolina Goodman. Carolina, you are unmuted. Please go ahead with your question.
Hello, thank you, everyone. This is Carolina Goodman, and it's a question for Peter Bibbering. You mentioned that legislation has helped to address accountability. Can you discuss a little bit about how SB 1421 and AB 392 have been working?
Sure, I'll be very brief on this. I mean, I think, first of all, with respect to AB 392 and the change in use of force standards that went into effect last year, I mean, it's a little too soon to tell. As all of us know, last year wasn't a typical year for anybody. And so it's a little hard to tell, there are unusual trends in all across public safety and criminal justice. And so it's a little hard to tell how it's working. And in fact, in many departments, they're still in the process of implementing. We haven't seen how those standards will fully be implemented in civil or criminal cases, but I remain hopeful. With 1421, what we've seen over the past couple of years that records have now become available is a real window on what law enforcement discipline looked like at agencies across the state, and that's been very helpful. In fact, that's one of the part of the genesis of the decertification is we've actually been able to see how officers who committed serious misconduct at one agency were rehired at another agency, and that is an issue that really needs to be addressed. But there's a great deal more transparency than there was. I think, not enough. And I think actually, again, I've talked about the IG's report over and over, but I'll say again, one of the things I read as going through the IG's report was how much information at the Sheriff's Department is not contained in records, how there were deliberate efforts not to commit certain things to writing, agreements about settling discipline, how the summary statements by the IAB, the investigative division of the Sheriff's Department, didn't include important information or even misstated important information. And I think that's something that we really have to be aware of, that we have a window into those records now, but we still, there's so many of them, and we still are going to have to rely on watchdogs like the IG to conduct audits of investigation to fully understand. But it's very helpful now that when those audits are released, they can release the materials on which they're based, instead of just saying it's all secret, but trust us.
Thank you, Peter, for explaining the status of those two important pieces of legislation. Jennifer, I think we could take another question.
Excellent. Paul Hernandez, you are unmuted. Please go ahead with your question.
Yeah, hi. Thank you very much. Hi, Gary. Paul Hernandez here. I don't know if you remember me from SOD.
I do, Paul.
Force Investigation Division, retired captain from LAPD. My question is probably to the panel: culture, past practices, loyalties to your partners, supervisors, and the industry have a lot to do with the breaking down of the attitude of some of the law enforcement agencies. And in order to get to holding each officer accountable for their own actions, you almost have to increase your audits and checks and balances. I was the commanding officer of a couple of units there in Los Angeles that were not well liked. The Special Operations Division, who basically police your own. And that attributes to trying to develop that trust between law enforcement and the community. The question is how do you begin to put a plan together to make every officer accountable for their own individual actions? I know when you take that badge, you take that gun, you promise to do that, but over time, that kind of erodes.
Right. Who wants to start with that one? That's a good question. How do we put in a plan, perhaps even change culture so that each officer can be and understands that it's important to be accountable for their actions? Peter, let me start with you, and then I'll ask you.
Yeah. I mean, I think certainly let's start with at LASD. There are a number of structural and policy changes that are crucial to address immediately. I mean, we've talked about some of them, starting with concurrent administrative investigations, but fixing these kind of glaring problems with the department, such as that there's no mandatory duty to report misconduct. There's no requirement to cooperate of other deputies, that there's no duty of candor to report a full account of what happened if a deputy is interviewed in the course of an investigation. no mandatory investigation of reported conduct, the fact that when an investigation is started into one issue, if they uncover a different misconduct, so they do a domestic violence investigation and they discover that another deputy lied about the domestic violence, that it is the policy and practice of the department not to formally initiate an investigation or report that misconduct. There are just a number of just structural problems with the policy that can be changed. And I think, look, the point of this, though, is to get back to this core idea that all misconduct is investigated, all misconduct is evaluated, it's investigated fully and fairly, and discipline is fairly imposed so that the public and officers can trust in this. I will say two quick things. One, if the sheriff doesn't do this, the board of supervisors could. They could direct the department to make these structural changes and require it by ordinance, and they should do so. And two, aside from these structural changes, there is a real leadership issue as well. And Sheriff Villanueva came into office making one of his top priorities to reinstate deputies that had been previously fired, making allegations, which we now know to be, and the IG's report says, unsupported, that the process was somehow flawed, and reinstated, terminated investigations into deputies, reinstated deputies, and apparently, as the IG's report indicates, is widely understood to have said that there's no path for advancement at LA Sheriff's Department for a deputy who puts a case on another deputy, and he's done nothing to address that. And if there's that culture at the department that comes from the top of essentially an open season on misconduct, that deputies aren't going to be held accountable, then all of the policies on paper aren't going to help anything.
Okay, and let me thank you for that. Mr. Engemonson, you described the LAPD system, disciplinary system, but if you were putting together a plan, not necessarily just for the LAPD, but and I realize you have limited knowledge of the Sheriff's Department, but what kind of plan could you would you think of to increase accountability by individual law enforcement officers?
I think LAPD does a good job, and I say this because there's a policy that we take complaints from citizens, period, to the extent where a lady walked into Devonshire Division and accused an officer of stealing her ovaries, and we took a complaint on it because the policy is that you take complaints on everything and they're investigated. We have in our manual a section that says you will immediately report misconduct if you observe it on or off duty, and many officers will get dinged for that. You see it routinely. We have Paul ran an undercover unit, as I recall, that sent out UCs to make personnel complaints to see if complaints were actually taken, and that would set up scenarios in parks and various places on radio calls that were phoned in phonally, and then everybody was monitored and filmed on whether they handled it correctly, and whether the reports were accurately written. So there is an robust undercover going on. We have an entire division dedicated to audits. Body-worn video audits are routinely done on a basis of selecting it from a computer program that randomizes things for officers to look, for other people, auditors to look at the body-worn video to see if everything is. And we have a zero tolerance for dishonesty. So, and you know, of course, when human beings run things, it doesn't always work out perfectly. But I think the LAPD is like exemplary in its attempt to hold officers accountable, and the officers themselves look more on it like it's effective that they feel oppressed. They're driving.
Let me ask
complaint.
Maybe you can help. Maybe you can help us here, at least as the Sheriff Civilian Oversight and Sheriff's Department, by let's just say that a citizen files a complaint that he's been stopped by an officer and he's in his car and he's punched 5 times in the face. In the LAPD, would that get investigated by internal affairs
Roll
always or only sometimes?
No, there would
Pardon?
be a rollout team on that. And then, of course, body worn video is on every officer
Oh,
and
yeah,
car camera.
okay, but just bear with me for a moment. I mean, right now, let me just explain to you that my understanding, and I could be wrong, but reading the IG's report, in the sheriff's department, the initial decision whether or not that's investigated, what I just described to you, is by the unit commander. The unit commander can say, I'm not referring this to Internal Affairs Bureau. We'll just investigate this within the unit. A unit in the sheriff's department would be a patrol division. Let's say the Altadena Patrol Division, East LA, and so forth. But it seems to me a better system would be that case is always investigated, and it should be investigated by the Internal Affairs Bureau. Now, that doesn't happen in the sheriff's department. At least it's not a policy that requires it. How about the LAPD? Could
Yes.
the captain of a precinct, the Hollenbeck precinct or Devonshire, just say, no, I'm not. We don't need internal affairs to investigate this. We'll do our own investigation of this allegation that seems pretty serious on its face: unprovoked assault, a use of excessive force on a citizen.
Yeah, well, it could go down a couple different ways. First of all, the officers have an obligation to report use of force, whether it's non-categorical, which means light, or categorical, which means deadly force, to do it. But if a citizen calls in and says, yesterday or 5 hours ago or 10 minutes ago, officers pulled me over and beat me, that would go directly to internal affairs, and a rollout team would come out and check that right at that time. There wouldn't be any sitting down on it. And there's a list of things that are not handled by divisional personnel complaint investigators that go immediately downtown, and excessive force complaints would be one of them.
Okay, so, all right, no, thanks for that. And that might be a list we would like to take a look at. Ms. Kamlinger, unless you have a comment here, I'm going to go to the next question. Did you want to comment on this one?
I was just going to say there's a huge difference between, policy enforcement of that policy and culture. And leadership is incredibly important, and it goes, how are we supporting law enforcement by giving them refined tools for decision making? How are we working to make sure that folks have, higher educational levels? The reality is, no department, no group likes snitches, and if you feel that the success of your organization is dependent upon everyone sort of towing the line and helping each other, then that's the culture. And it's really hard to permeate that with policy. And so I think one of the things that works in many other, organizations, in sports, in academia, is when you sort of infiltrate those bodies with outside thinking and folks from different practices to allow in a safe space to uncover some of the biases, some of the bad practices, and some of the condoning that happens of bad behavior, to reveal that in a way that lets the organization see, the steps it needs to take to heal itself, so that it has a higher degree of credibility with other partners like community members and citizens and residents, as well as within its own ranks. But it certainly, you cannot heal yourself if you don't have someone else coming out to look at what you're doing with fresh eyes.
Thank you for that. Hopefully we can get in a couple more questions here. So the next question there, we have about, 7 or 8 minutes.
Sure, and the next question will come from Francine Harris. Francine, please go ahead with your question.
Good morning, panelists. My question would be to Gary. You just spoke on excessive force. So I would like to know what safeguards can be put in place to police to use the appropriate level of force and provide objective evidence in situations where police use deadly force.
Well, the most effective thing that I can think of is that all body-worn video, all officers have body-worn video, and they have in-car camera video, and there are very strict rules on when to turn it on when you're contacting a citizen, and almost every use of force has body-worn video to be examined by everybody through the chain of command that looks at it, including if there's unreported uses of force, the auditing will often pick it up. And then it goes through the system, and there is a use of force board that looks at categorical uses of force. It's 5 command officers, and the captain comes in and makes a recommendation, and then the use of force board makes a recommendation to the chief of police, and then the chief of police makes a recommendation to the police commission. And whether the use of force is in policy or not is entirely up to 5 civilians, the police commission. So I think there is oversight, not to mention the fact that at the scene of the use of force, the categorical use of force, is the IG and the district attorney, and now the AG will also take part in shootings where there is an unarmed civilian. So there's a lot of oversight, layers of it.
So that was for Gary. Can we get in one more question, Jennifer?
Absolutely. And our next question will come from Daryl. Daryl, you are unmuted, NAACP. Please go ahead.
Yes, hello?
Yes, we hear you. Please go ahead, Daryl.
My name is, Daryl Goo, Stamach NAACP, but I'm speaking on behalf of we've got 15 branches in LA County. And I have several questions, but you don't have enough time. But overall, we've looked at the whole process of electing sheriff, and we've had several meetings with the sheriff. How do you change a system from the top that is inherently corrupt? I mean, when you have someone elected as sheriff, is only a lieutenant, you put them in charge of 18,000 personnel sworn, and we looked at you go back and look at the sheriff's website, all those commanders also promoted from lieutenants to commanders without like the LAPD and they have a merit system. You put all these people in charge, and we've got it from good intel that commanders are paid to help solicit the election of the sheriff. This is something you need to look at top, because you've got all these people in here that have got these positions, and you have these issues. So it's a real challenge to, at the very top, and all this other stuff is piece of Bill of Rights that's in conflict with the U.S. Constitution. And you protect. There's a whole. We don't have time for that, but
yeah. Let me just say. Let me respond here. Let me respond to the question, Errol, and say that you're right. If at the top you don't have a chief or the top of the organization who's committed to having an effective disciplinary system, you're probably not going to have one. So that you need to have that commitment at the top. But this is also an issue that is being looked at, certainly by the Board of Supervisors, and I believe perhaps the state legislature, to see, at least examine, is there a better option to Sheriff's Department, a better option than electing a sheriff? And then what is that option, and how would the sheriff be appointed if you went to some other system? And it's a pretty heavy lift, by the way. It probably is going to require not just legislation, but a constitutional amendment, since the sheriff is a constitutional officer under the California Constitution. So, but it is being looked at, and it's a valid question. I appreciate you raising it. Did Ms. Kamlinger, we have maybe just a moment if you wanted to comment on that one.
No, that's right. There's also, as I mentioned, legislation that's been introduced that says you don't have to be from within law enforcement to run for sheriff. So that's also something that's on the table.
All right. Jennifer, unless you tell me we have more time, I think we have to wrap this up, but I'd love to be able to take more questions.
Yeah, I agree with you, but we do have commitments from our panelists that they would be here until 10:30. So if any of the panelists do need to leave, I invite you to sign off if you would need to. And Judge Bonner, would you like to take one more question?
I would like to, and I'll ask the panelists if they can to stay on, but we'll understand if any of you have to drop off. Yeah, let's take at least one more question here.
Okay. And the next question will come from Lloyd Wilkie. Lloyd, you are unmuted. Please go ahead with your question.
Good morning. And I want to say thank you to Ms. Kamlinger for stating what she did just previously in regard to community members having more input into the direction of law enforcement. My question has to do with the fact that the previous sheriff had identified 300 problematic deputies. He attempted then to turn that list over to the DA, who I think refused to accept that list. I don't know all of the details of that, and perhaps you may. I was just wondering if you'd like to speak to that, and maybe to what's been the outcome of that list, for example.
Yeah, I can. Who wants to take that? I'll just say that there was an attempt by the previous sheriff to turn over what was called the Brady 300 deputies who had been disciplined for serious misconduct that could affect their credibility as witnesses in criminal prosecutions. And I don't think the prior DA refused it, but the union, the ALADS union, took the former sheriff to court and initially got a bar from turning over that list. Then ultimately the Supreme Court of California weighed in, and it seems possible that you can, but I haven't reread that case. Peter, this is probably a good question for you. What's the status of the Brady list, and both in terms of the legal ability to turn it over and whether there's any inclination to do so?
Yeah, well, I think you're exactly right. The Supreme Court made clear that legally the department's allowed to turn it over, but since then the sheriff has changed, and the current sheriff has no desire to turn over a list of officers that have been disciplined for misconduct. I will say that many of the names on that list, to the extent it is based on findings of misconduct that are public under SB 1421, should actually be available to the public. I mean, there may be some officers that are on there for conduct that's not dishonesty or sexual assault, and those would have to be redacted, but the others should be turned over. We've made a request to the department and they have refused to turn it over, and we're currently litigating that issue because they are refusing to turn over a document that I believe is just unambiguously public information.
Yeah, and according to the public media, and here I'm relying on the LA Times, the new district attorney in LA County may have requested that the sheriff provide the Brady list, but we'll see what happens. It's a work in progress. Maybe would we have time maybe for one more question? Just beyond the Brady list. Jennifer, is anybody else queued up there?
Sure, yes, we do have a lot of people who have asked questions. Please feel free to email them if you haven't gotten to them. The next question will come from Nick Arnzen. Nick, you are unmuted. Please go ahead with your question.
Hi, thank you all for being here. It's a pretty direct question. I think you've basically answered it, but I promised some constituents, residents and racial justice groups out here in Altadena that I would ask it today. They're concerned about getting access to complaints which are rebranded as service reports from the LASD. I found out that that's not available to them because they're attached to personnel records. Are those ever available? And if not, is the status available? Because we're not able to get direct answers from the Sheriff's Department. This would go to any one of you because I'm not sure who could answer it.
Yeah, I think, Peter, this is probably a question that you're going to be the most knowledgeable on. But can you answer that one?
Yeah, I can be very brief. I mean, this is one of the issues. Although for most types of government employees, any complaint that is substantial in nature or which is interpreted as not frivolous is available to the public. That is not true for peace officers. For years, all complaints and investigations of complaints were secret, even when ultimately they revealed misconduct. That changed a couple of years ago with SB 1421, where some narrow categories of the most serious misconduct were finally open to the public, but that's only for findings related to dishonesty and sexual assault and then for investigations into serious uses of force. So if there are complaints about misconduct that doesn't fall into those categories, those are not public, even if their deputies have found to have engaged in misconduct, and even if they do allege those categories of serious misconduct, they're not public unless the department sustains it. And of course, the public often wants to know kind of most urgently if there's an incident where the public knows that there's or thinks that there's dishonesty and it's not sustained. That's when you want to know why, right? In order to understand the process. And so that's part of the problem. I will say one thing, that there's a bill introduced by Senator Skinner, I believe it's SB 16, which would expand somewhat the categories of complaints that are available to the public.
And the reason the complaints are not available, unless they fall within, they've been adjudicated and fall within AB 1421, is that state law, POBAR, there's a related statute under POBAR
that's right,
that prevents the release of that information to the public, correct?
That's right, and that's unique for law enforcement.
Unfortunately, we just lost our state legislature, so it would have been nice for her to hear that point. But
code, Honor,
yeah, Gary.
It's in the penal code. It's 837.5.
Yeah.
And I will say that I know that Assemblymember Kamlager was introduced on the assembly floor Skinner's bill last year, so I know that she is aware of the effort to expand and has been supportive of that. That effort actually passed both chambers of the legislature last year, but just due to the late hour, it passed in just a couple of minutes before the constitutional deadline. It ended up not getting transmitted to the governor. So they're back this year to. And
all right, so maybe perhaps some progress will be made on that front. Again, where you draw the lines is probably important here. I don't mean to say that that's an easy one, but it would provide greater transparency the more there is access to the disciplinary process and what happened with a complaint. Let me, I've imposed on our panelists, but can we do one more question and then we're going to wrap this up? Jennifer,
Sure.
Do you have somebody else in the queue there?
Yep, and the very last question will come from Michelle Infante. Michelle, you are unmuted. Please go ahead with your question.
Thank you. Good morning, everyone. My name is Michelle Infante. I'm with Dignity and Power Now. My question is, with the scathing report that Max Huntsman put out on internal practice standards not being met, what does that say for externally? I mean, it's very scary to wonder if they can't handle within their own department internal misconduct. How can we trust the integrity of an investigation that's done out in the field? We just can't. How do you reconcile the two together?
Yeah. Okay. So, all right. I think I've got that question. Let me let's finish with that question. We'll start with you, Gary, then we'll go to Peter.
I'm not familiar with the report he's talking about. I'm sorry.
Well, okay. All right. So you don't know the IG. You haven't read the IG's report, and by the IG we're referring to here is not the LAPD, but the LA Sheriff's Department IG. Peter, can you perhaps respond to Michelle?
Yeah, I mean, I think that's exactly right. I mean, and it goes to the core discipline. If you can't, if the disciplinary system is ineffective and you have documented evidence that there's dishonesty happening at the department that's going that's being allowed to happen with no accountability, with the disciplinary system not flagging it, not investigating it, even when they investigate it, not holding deputies accountable, that undermines public trust in the department and in its ability to do its core job of investigating criminal activity. And that is why systems of discipline and accountability are so crucial.
Okay, look, I think we need to wrap this up. So I want to thank our panelists for sharing their thoughts, their ideas, and their insights. And I want to thank the members of the community for tuning in to this important dialogue. Obviously, it's a work in progress for the Civilian Oversight Commission. Sorry we couldn't get to everybody's question, but we did get to at least some of them. So to stay informed on upcoming programs hosted by the Civilian Oversight Commission for the Sheriff's Department, visit coc.lacounty.gov. I want to thank you all. Stay healthy. And that concludes today's conference. Thank you.
Thanks.